Welcome to Public Health on Call, a podcast from the Johns Hopkins Bloomberg School of Public Health, where we bring evidence, experience, and perspective to make sense of today's leading health challenges. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes.
This is Lindsay Smith-Rogers, producer of Public Health on Call. Today, we turn to the bankruptcy of Purdue Pharma, the makers of Oxycontin. Andy Dietderich is an expert in bankruptcy law and co-head of finance and restructuring at Sullivan and Cromwell, a major law firm in New York City. He joins Dr. Josh Sharfstein to explain the basics of bankruptcy, how the controversial Purdue bankruptcy deal came together, and what is happening now before the U.S. Supreme Court. Let's listen.
Andy Dietderich, thank you so much for joining me on Public Health on Call to talk about a topic that we don't really think very much about in public health, but has been a big part of your career, bankruptcy.
Thanks, Josh. My pleasure to be here.
So bankruptcy to a public health audience these days means Purdue Pharma, the company that made Oxycontin. And I wonder if you could help me understand how this bankruptcy works.
Sure. Well, it's obviously an incredibly complicated bankruptcy and a complicated set of facts. One of the most complicated bankruptcies ever filed. But the most important thing I think to understand about the bankruptcy is it's just a bankruptcy of Purdue Pharma. It's not a bankrupcy of the Sacklers. The reason why it's not a bankruptcy of the Sacklers is because the Sacklers are a diverse family. Whatever assets they have are sprinkled all over the world. And they are owned, for the most part, in a series of trusts and other corporate entities in jurisdictions where they've placed entities to shield them from creditors. So it would be very difficult to run a global bankruptcy that includes the Sacklers and the Purdue Pharma business. So when we talk about the Purdue Pharma bankruptcy, the most important thing to understand is it's just Purdue Pharma. And what is Purdue Pharma? Well, Purdue Pharma was a company organized by the Sacklers to manufacture, sell, and distribute opioids. Unlike a lot of other businesses, it really wasn't a fully diversified business. They had a few other business lines, but Purdue Pharma was virtually entirely an opioid business. And so when we think about what Purdue Pharma is in the Purdue Pharma bankruptcy, we're talking about what do you do with this legal entity called Purdue Pharma that faces, on the one hand, billions, if not trillions of dollars of claims. And on the other hand, has assets that are very limited. You know, it's tradition, the business that it was operating, insurance rights, and most importantly, very large claims against the Sacklers. But in the popular understanding, you know, probably the most important thing to understand about the Purdue bankruptcy is it's not a bankruptcy of the Sacklers. It's just a bankruptcy of Purdue. And the insolvency professionals working on the Purdue Pharma bankruptcy had to deal first and foremost with that reality.
So how does this bankruptcy play out? What's the forum?
Bankruptcy is a federal statute, and it gives a federal court, a bankruptcy judge, who's a specialist court, authority to resolve all of the legal questions that relate to the bankruptcy. And bankruptcy law as a federal law preempts and has authority over state law. So if there's a conflict between a state law and what the bankruptcy code says, the bankruptcy code governs. However, what's important to understand about bankruptcy is it's just a limited statute about what to do to how to run a bankruptcy case, how to decide who gets what. Bankruptcy law doesn't actually determine anybody's pre-existing or underlying legal rights. Bankruptcy law takes that all as a given. And this is another really important thing about the Purdue case, because as bankruptcy lawyers, we often say that, you know, we're the janitor. We didn't make the mess, right? And you can't blame the janitor for the mess. And there's a lot of what people want bankruptcy to accomplish that it wasn't intended to accomplish. For example, it doesn't punish people, right? If you want to punish people, bankruptcy is a really bad place to do it. Because the central idea of bankruptcy law is you got a mess, clean it up, minimize the damage, maximize the recoveries, and try to allocate them fairly to people. who are obviously going to be disappointed because by definition, it's a bankruptcy. There's not enough to go around.
Right.
And this is really important when you think about Purdue. Because when you think about Purdue, the bankruptcy system is not determining the kind of the opening position. The opening position before the bankruptcy starts is kind of weighted in favor in Purdue and weighted in favor of the Sacklers. The opening position favors the Sacklers in the following way. The U.S. law generally decided, not bankruptcy law, U.S. corporate law decided that we have a corporate veil and you can form a company and the company isn't liable for, the owners of the company are not liable for the company's debts, right? Not a bankruptcy decision. In the case of Purdue Pharma, the company is owned by mostly offshore trusts. Those offshore trusts are in jurisdictions that have competed with each other for 50, 60, 100 years to be the best place for wealthy people to shield their money. What happened in Purdue Pharma is all the money made by Purdue Pharma, which is, as everyone knows, the vast majority of the source of the family's wealth.
Right.
All of that money was made by Purdue Pharma, was then distributed to the trusts, and then distributed to the Sacklers, to grossly oversimplify.
So the people who want access to the money are having to deal with not just Purdue Pharma, but they're trying to say, we know that Purdue Pharma distributed that money elsewhere. We are hoping in this bankruptcy proceeding to get at that money, but it can be very hard to do so.
Exactly. And I mention that because any bankruptcy is a collective action problem, right? What bankruptcy is designed to do as a statute is to solve a collective action problem. In the simplest level, there's a company that has 10 creditors. It owes $10 to each creditor, and it's only worth $40. Okay? So it can only pay people a certain amount of money. Bankruptcy is designed, if I'm a creditor, to stop me from, and you're a creditor, we're both creditors, designed me from getting ahead of you or you from getting ahead of me. It creates a collaborative process where we have to do so jointly. It also gives us as creditors and the estate, which is our name for the debtor representing the creditors, all of these great tools to go out and maximize the value of what we have. If we have something, we can sell it. If we have litigation claims, we can pursue the litigation claims. But ultimately, we're supposed to be doing it jointly.
So is what's happening in this proceeding that the Sacklers themselves have taken some money from those trusts and essentially put it on the table and saying, okay, we'll contribute to this bankruptcy of this company, but in exchange for that, we don't want any liability for ourselves. Is that essentially what's coming in? And in a way, they're taking advantage of that strong opening position to say, like, we're not even sure you're ever going to be able to get this money that we've socked away, but we'll put some of it on the table in exchange for this provision.
That's essentially correct. I think, and embedded in your question is, in bankruptcy, we often have to ask the question, who's we and who's they and who are us, right? And so it's important to focus for a moment on the creation of the bankruptcy estate as a representative of creditors and as a counterparty to the Sacklers. Right? So what the bankruptcy professionals did in the Purdue Pharma case, and they did it very well. So well, in fact, that although the public, there's lots of allegations that, the Sacklers controlled the bankruptcy. If you look at the actual record of the bankruptcy, it's very clear that the first thing that was done in the bankruptcy was to create this estate that I mentioned, right? This representative of creditors vis-a-vis the Sacklers. And the estate marshals and collects all of the arguments that it has in order to kind of sue the Sacklers to get the money back or threaten the Sacklers to get the money back. And in response to that, the Sacklers said, we will, first of all, walk away from our ownership of Purdue. You can have Purdue. Second, we will agree to make a series of payments over time. Initially $3 billion, then $4.5 billion, and I think at the end of the day, something more. And that money will then be contributed into a general pot, which will be used for the various purposes set out in the plan. In return for that, the Sacklers wanted, of course, releases. They wanted to know this was it, and they wouldn't continue to be sued. And that's the essential deal. It's not an unusual deal in bankruptcy. For bankruptcies designed to, achieve finality in that way and allow people to have debts to be able to settle it and then move on.
And yet this deal was challenged particularly by some, I think, attorneys general and some others who said that it should not have allowed the Sacklers to get those releases?
There's two kinds of challenges, right? There's one challenge that says it wasn't enough, and another challenge that says you can't do it, even if it was enough, right? And it's very important to draw that distinction, because one of the things that is sometimes lost in the debate about Purdue is that it had overwhelming support from the states and from the victims' representatives.
The settlement.
And the staff, overwhelming. So even before the case was filed, the initial settlement, the $3 billion settlement, to simplify, was supported by 24 states, 5 territories, the lead representatives of the plaintiffs. And the initial bankruptcy filing was consensual with most of the creditors. And it was only some of the creditors, some of the states, that were objecting during the case. By the time they were done and additional money was put on the table and they went through 3 mediations, et cetera, they had 80% of the states supporting the plan. The plan was put out to vote among the creditors. Of the creditors who showed up to vote, 95% approved it. Right? So although, as I said, you might take the view that pre-bankruptcy, the opening position was weighted in favor of the Sacklers, all the creditors involved in it, for the most part, looked at that settlement and concluded that the settlement was fair given the pre-bankruptcy situation. So the question of did the Sacklers pay enough? I mean, even the judge in his opinion said, I wish they paid more. I was disappointed they're not paying.
Right.
But that's a function of, the offshore trusts and the difficulties collecting, et cetera. I think the general sense, at least the way everything has settled, is that the settlement reflected is as fair as bankruptcy is really able to provide.
Got it. And yet you have this other question that's still outstanding.
The other question that's outstanding is a bankruptcy lawyer's question, is a technical question. Okay. And the technical question is, can you really use bankruptcy to do something this complicated? So we know you can use bankruptcy to resolve the affairs of a debtor of a single company or a group of companies. But can you use bankruptcy to not only resolve the affairs of Purdue Pharma, but also to release all of these claims against the Sacklers by so many different people? Is that fair? Is that an appropriate? Well, it's not even a question whether it's fair, because I think most people looking at the facts would say, yeah, it's fair. The question is, did Congress authorize the bankruptcy code? Does the bankruptcy court have authority to do this?
Well, people might say it's fair for there to be an agreement like this, but people might still think it's wrong ever to release the Sacklers.
Well, I should mean what I say by fair, right? I mean fair in a kind of a narrow bankruptcy lawyer sense.
Yeah. That
given the claims everybody had against the Sacklers in the opening position,
right,
and the opening defensive position of the Sacklers legally, is this a fair resolution, a fair payment, right, given the legal rights? And I think the answer to that, at least the judge determined, and most people looking at it determined, yes. You could also ask yourself the question, should the Sacklers, is the law treating the Sacklers fairly? Right. Should the law be tougher? Was there crime, right, et cetera? All these questions are beyond, above the pay grade of the bankruptcy lawyer. But bankruptcy has to take all of that as given.
Understood. So what's before the Supreme Court now?
So before the Supreme Court is an issue of whether or not the Sacklers can be released completely from all of the liability associated with the opioid activities of Purdue, with a particular focus on one kind of claim. And that claim is a claim by an individual victim or state directly against the Sacklers. It's not disputed that the bankruptcy can release claims against Purdue Pharma. And it's also not disputed that to the extent Purdue Pharma has claims against the Sacklers, that the bankruptcy can release and compromise those claims. The open question is whether or not a bankruptcy can release what's called these direct third-party claims.
Is essentially the argument that a bankruptcy court shouldn't be able to take away my right to sue the people who I think harmed me directly?
That's a great way to put it. So let's focus on you, Josh, okay? And let's say you, Josh, have a claim arising out of, a claim arising out of this. What right does the bankruptcy court have to take a claim away from you, Josh? Now, if your claim is against Purdue Pharma, right, which it would be, the bankruptcy code says we can take your claim away. And the reason we can take your claim away is because Congress granted the bankruptcy code pursuant to the Constitution,
right,
the right to impose a national bankruptcy law. And the national bankruptcy law says, Josh, I'm sorry, you might want to sue Purdue Pharma, but stand in line with everyone else.
Right.
And you're going to get the same recovery. You all have to work together.
Right.
And at the end of the day, there'll be a plan proposed that will take away your claim and hundreds of thousands of other claims and will pay you each the same recovery. And you're allowed to vote, yes or no. But if you're outvoted by a certain percentage, then that settlement can be imposed on you and your claim can be taken away. The question before the Supreme Court is if you also have a separate claim against the Sacklers or a claim that you allege is separate against the Sacklers, can that claim be taken away from you as well? And that's an open legal question.
Right. And there seems to be an understanding that if Supreme Court finds that, in fact, people can still go sue the Sacklers, that maybe the whole bankruptcy agreement might fall apart. What do you think is likely to happen?
Well, I think that in the first instance, the question is overblown in its importance. Because let's go back to what, Josh's claim against Purdue Pharma. Your claim against Purdue Pharma could be taken away with you with a vote, right? You can be outvoted on that. If you assert a claim against the Sacklers, what's the basis of that claim? It's actually pretty hard to think of a claim against the Sacklers that's not really, in essence, a claim against Purdue Pharma.
Right.
Right. And so this debate about Josh's direct claim against the Sacklers is actually not as important as the definition of what is Josh's claim against the estate and the estate's claim against the Sacklers. And if those two categories are defined broadly enough, your claim against the estate and the estate's claim against the Sacklers, the leftover exposure, if you will, or the leftover claim directly against the Sacklers that's unrelated to the business of Purdue Pharma, may not be all that important. So I'm interested in the Supreme Court's resolution of the direct third-party claim question, of course. But you have to keep it in context because we already know that everything that your claim against Purdue Pharma can be released and your claim against the Sacklers can be released to the extent it really is a claim against Purdue Pharma or really is a claim by Purdue Pharma against the Sacklers.
So you might, just pulling this together, it sounds like even if the Supreme Court says that it's okay for people to directly sue the Sacklers, that the bankruptcy court can't take that away, you might make the case that the agreement should go forward because the chance of anyone being successful is going to be pretty low. And there's still such value to the settlement for both sides that perhaps this turns out to be something that's not nearly as important as some people are worried about.
Even if the Supreme Court were to say that there's not adequate authority under the bankruptcy code to release direct claims by creditors against shareholders, they're going to say, unless those claims have a certain nexus or relationship with the bankruptcy. And the question is going to be, what's the level of that nexus or relationship? And most of the stuff that's important in these bankruptcy cases will have a sufficient nexus or relationship, I think, by the time, lawyers and judges have digested the consequences of anything the Supreme Court would do.
I have learned so much from this conversation. Thank you so much for joining. I think it gives a sense of what's at stake and how this could play out. And I started by saying that public health, we don't think about bankruptcy so much, but you have broken it down for us. I really appreciate your time.
My pleasure, Josh. Thanks.
Public Health on Call is a podcast from the Johns Hopkins Bloomberg School of Public Health, produced by Joshua Sharfstein, Lindsay Smith-Rogers, and Stephanie Desmond. Audio production by J.B. Arbogast, Holly Cardinale, Philip Porter, Spencer Greer, and Matthew Martin, with support from Chip Hickey. Distribution by Nick Moran. Production support from Catherine Ricardo. Social media run by Grace Fernandez and Shian Briscoe. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes. Thank you for listening.